Good afternoon, everyone. Thank you for joining our webinar, Physician Practice Employment from Staff to Technology. Our speaker today is Kelly M. Jolley, the attorney with Jolley Law Group. The presentation map, the objectives for today is at will, harassment, discrimination, protected categories, wage and hour, FMLA, employment practices, liability insurance, and best practices. I'll turn it over to Kelly.
All right, everybody. I'm glad to be here with you today. My main reason for giving this presentation is that I find for the past 19 years, I've primarily worked with physicians, and then I'd say more recently, other licensed healthcare providers like nurse practitioners and PAs. And a lot of times folks will come talk to me initially about a regulatory problem, specifically a licensure issue, HIPAA, a technology problem, or a contract issue they're having with a hospital system or with other physicians. But more frequently after that, I would say at least 50% of the issues they bring when they come back are actually about employment. And a lot of times the things they're asking about are sort of basic general employment questions, but these are just not things that folks necessarily know. And since most physician practices in both Georgia and South Carolina are small, they are usually not big enough to have on hand or on site a full-time HR person. So I don't do HR, but I do employment law. And so a lot of times when people come to me, there is a problem with an employee that we probably could have fixed in a better way without litigation or whatever if they'd known some things up front. So that's the purpose of this. This overview is just to give you an idea of things you might should look for and some tips for how you can avoid future problems. So first, employment at will is something that's very popular to talk about. I got a letter from a client that basically told an employee, we're terminating you in this role because of your availability issues, period, and signed it. And when I said, well, that letter seems likely to lead to some more problems, they said, but we're employment at will. We can fire them for any reason or no reason. That's true. But let's talk about what employment at will really means. So first, whether or not you sign an employment contract, and a lot of times folks will only issue offer letters for non-physician or PA employees, you are creating an unwritten contract under the law for an employer-employee relationship. And if it doesn't state in that contract how long the contract lasts, then what we're going to say is that the contract lasts at will. In other words, for however long as both parties to that agreement want. So if you think back to history, maybe you learned about serfs in England and Europe and Russia and other places. And serfs were people that had to work at a specific space because they were tied to the land. They were born on the land. They were required to work on the land. They did not get to quit. They could be fired and kicked off the land by the landowner, but they could not choose to quit. What we have with employment at will is that no one can make you work. If you do not want to work, you don't have to, you get to leave. The other side of that coin is if they do no longer wish you to work, they can tell you that the relationship is terminated, and they don't have to do it for cause. That's what no cause means. We are terminating based on the fact that this is no longer a relationship we want to continue, and you're giving them notice. There are still exceptions to the employment at will doctrine. So just because you have an employment at will, and you can have that in a written agreement too, a lot of times the written employment agreements that we draft for folks or review for physicians are going to say that there is at will employment. That means that either side can terminate. But a lot of times there's going to be something in that agreement that limits that ability to terminate. Most commonly in a physician contract, you're going to have some sort of notice provision. They can terminate for any reason or no reason so long as they provide 30, 60, 90, or 120 days notice, okay, in written notice. It's still an employment at will, but it does now have a notice provision that at least gives you a guarantee of however long that notice provision is. Most such contracts will also allow for employment be terminated for cause with a less amount of time. Other exceptions are if you did not write your agreement up front, but you make an oral agreement and y'all both perform under that oral agreement, then the other party could enforce that oral agreement against you. Another exception is public policy. So there's several things that we say, yes, you can terminate a person, but for example, you can't terminate a person for being an old woman. All right. That is because a person's age and sex are both protected classes, which we'll talk about. And you're not allowed to use those reasons as reasons to terminate. So in that case, we just want to make sure we have another reason to kind of justify the termination, even though it's not for cause. And what we might say is, hey, we don't really need this position, or this employee is having difficulty getting to work, or we need to get a cheaper employee or something. We have to be able to say it, and it needs to be something that is not against public policy. It's obviously, and you'll hear me say this many times today, it's obviously very difficult to prove what our reason is if we've never written it down or creating any documentation. So that's one of the reasons that it's always important that you do a termination letter that states the reason for the termination. Okay, breach of the implied covenant of good faith and fair dealing. Whether or not you've got a written agreement, in every contract, there is an assumption that both parties will act with good faith. That means that they will attempt to do what the contract says. If they fail, then that you can be found in breach of it, even if it's not an express contract term. And then sometimes you'll see something and people will say, well, yes, I was constructively discharged because of the way they treated me. This is something that I find people like to bring up. Well, I did quit, but they made it so difficult, or my supervisor was so rotten and rude. All of those things can be found as other issues. So these are things that you cannot terminate an employee for. If the employee refuses to steal for you, you can't fire them for that. If they choose to file a workers' compensation claim based on an injury that they have at work, you can't fire them for that. This is going to come up with, sometimes people say, let's look at the timing of this. All right. It's not always a great idea to fire someone when they turn 70, or the day after they file a workers' compensation claim, or a week after they submit FMLA paperwork, right? Some common sense makes sense. This is why I always tell people, if you have a problem with an employee, go ahead and address it up front. Don't wait until they have a timing issue now. For performing a legal duty, for example, you can't fire someone because they have been named to a jury. Or whistleblowing, and this is a big one. If they have come to you and said, hey, I think you've got a billing problem, specifically X, Y, or Z, or Tom Smith is harassing this other person, it's going to now be a problem if you immediately terminate them without some really good justification. In other words, for cause, because it's going to look like you're terminating them because they've reported a wrongdoing. And these are things that juries are very much in favor of the whistleblower. So if they can show that they presented it to you, and a lot of things happen now via email or text, which creates a record, you're not going to just terminate them at will. So sometimes I'll get questions from employers, particularly federally qualified health centers or other folks like that are like, why would we ever do an employment agreement if what that means is they get to use those terms of the employment agreement against us? Well, there's a couple of requirements in federal law that necessitate you enter one with particularly physicians. And this is under the Stark Law, as we call it after Pete Stark, the law's original sponsor and author. But it's really the federal physician self-referral law. And basically, even a physician in a practice could be found as having a problematic referral kickback relationship if there isn't a written employment agreement of at least 1 year's duration that sets out specifically what the compensation and the services to be provided are. So basically, you just need to know if you're ever hiring a physician or leasing a physician or doing anything that's going to have your practice paying compensation to a physician or that physician's spouse or child, you're going to want to make sure there's an employment agreement there to fit that bona fide employment relationship safe harbor. It's really this very similar safe harbor under the anti-kickback law. The difference with the anti-kickback law is it doesn't only apply to physicians, it also applies to nurses and PAs and anyone, in fact, who is going to provide a service. There's a list of specific services, but anyone who's going to provide a service that's going to be paid for by a federal program. Other reasons is a lot of times some provide certifications. particularly your malpractice. You want to make sure that if you hire a doctor, or if you're a doctor hiring another one, that you specify whether they have ever had a malpractice action, if they've ever had a licensing issue, or they've ever had trouble with credentialing. You get them to make those certifications in an employment agreement, because if they lie, then that gives you a reason to terminate and to find that you're not at fault. Same thing if you ever want to enforce a non-compete. Georgia has a good non-compete law for employers. Trade secrets or non-solicitation provisions, you're going to want to have a contract. And then, and most nurse practitioner and PA practice acts require that you have set out terms about what that provider can do. Okay, so next. So just like we talked about, you can't fire someone even if they're at will for something illegal. There are things that it is also just illegal whether or not you ever enter into a contract. And these are usually going to be found under Title VII, and they refer to discrimination and harassment. These are the two things I find most of the time. So there are these things called protected classes that tell us that we cannot discriminate. That means we cannot make a decision based on, and that refers to whether to hire the individual, whether to fire the individual, whether to give certain duties to the individual, or pay the individual in certain ways, or put them in a certain offices. Any of those things, you cannot make those decisions just specifically on that individual's race, color, religion, sex, or national origin. You can't do it. Now, there are a lot of other things that sometimes are thought to kind of align with those. Had a call from a client who was concerned about terminating someone that they hired to work at the front desk. She's a very nice African-American woman. The issue that they have is that whereas she had been in a certain role at a different practice, at the current practice, she did not have the skill set they were looking for the position. And they are also concerned about how she sounded on the telephone. She used a lot of slang that was turning off patients. And they wanted to know whether they could terminate based on her performance. And they're concerned about it. For one reason, they're concerned because she's nice. They're also concerned because she's Black. And they said, can we fire her? And I said, well, you can fire her if there's a good reason to fire her, or no reason. You need to change how you're organizing. You just can't fire someone based on their race. All right. One thing to know too is that when you talk about, we're going to talk about this, age is actually protected under statute, and that age discrimination actually starts at 40. So I have passed that threshold some time ago. Another thing, harassment. So harassment is any sort of act by one person that makes another one feel uncomfortable, offended, intimidated, or oppressed. All right. It has to happen in the office or whatever the workplace is. It's not usually considered harassment if it happens outside of your workplace in terms of like work, unless you have set up that situation. So if you sent a couple of employees to a conference or something and they're staying at the same hotel, that could cause a problem if you had like a work event outside the office. But usually it's going to need to be something that happened where one person makes the other person feel uncomfortable. It needs to be more than just sort of like, well, that was not a funny joke. Okay. But if it's a pattern or something, or if there's any sort of thing where they're feeling offended or oppressed, then that's a problem. It is a form of discrimination. So I think of those two as hand in hand. Okay. So like I said, those things are considered protected categories: race, national origin, sex, religion, and color. So you can't do those. Those can't be a reason. Okay. So just to make it clear, that means you cannot use those as reasons for hiring, firing, failing to provide certain benefits, changing disability leave or any other kind of leave. You can't mention it in job advertisements. In fact, you'll see most job advertisements or postings specifically say, we don't discriminate on these issues. Using any sort of facilities or any other terms and conditions of employment. One thing I will note, this came up during COVID when practices and other employers were having to lay off certain employees, or, at least for a period of time. And what I just explained is that you can certainly do that. We just need to make sure that the criteria you're using for those layoffs is very clear and obviously not based on any of those prohibited classifications. All right, sexual harassment. This can refer to anything where one person is making it awkward for another person. A lot of times, if, for example, someone refuses to give in to requests for a sexual relationship or dating or whatever, it can become hostile. Other times, it just becomes awkward for other employees if folks are having an inappropriate sexual relationship. A lot of times it's just weird touching. You know, I can remember a long time ago at working with a lawyer who I really just felt like needed to take his hands off my shoulders. I could not figure out why that would be something we ever needed to do. But I think most folks are usually clear now that it's not appropriate to make certain sexual comments about other people, but this can also refer to making comments about folks that are not there. So if you make a lot of comments about third parties, whether bisexual people or homosexual people or anything like that, in a way that makes other people uncomfortable, that could possibly fall under here as well. In every case, you need to make sure folks are very clear what to do if this happens and to whom they report. That's important for the employer. All right. So like I mentioned, there is also age discrimination. It's not a protected class under Title VII, but there is the Age Discrimination and Employment Act, and it protects individuals who are 40 years of age or older based on age. There's also an Older Workers Benefit Protection Act that applies specifically to benefits to make it clear that people cannot age out of your benefit program. Pretty much everyone knows that now because of the ACA, but before then, when it wasn't a requirement that you give everyone insurance, there were folks that are like, we provide insurance until folks are 65 or until they're 55 or whenever it became expensive, and you can't do that. I dealt at one point with a hospital system that circumstantially tended to let office managers go when they changed sort of management companies who were over 45 or around 50, and they had several of these leave. Some of them just left because they didn't like the work environment. Some were terminated for errors that they might make. Say they made a payroll error or a time card error or whatever. Those would be used to terminate. And honestly, we did not succeed in that case on overturning any of those terminations. We did get some smaller settlements, but the issue you have here is if the employer has a justifiable reason for the termination, even if we doubt that it's the reason, but if there is a reason and they can point to it as evidence and they had written up each of these things and the errors had happened, then they can terminate, but you can't terminate solely on age. All right. Similarly, pretty much everyone knows about the Americans with Disability Act. We know that it requires that we have bars and bathrooms and ramps and things like that. But it's also true that when an employer treats a qualified individual who has a disability unfavorably because they have a disability, then that's going to be seen as a violation of the ADA. Now, what do you have to do? What you have to do is make a reasonable accommodation. That means if there is a way for the employee to do the job that they already have with, say, a stand-up desk or a different chair or a special phone, things like that, then those would be considered reasonable accommodations. If you have an employee, however, whose health who say they had a deteriorating illness and their health condition comes to the part where they are actually having trouble getting to the office, then it might say, okay, well, this is a job they can do from home. If you let other employees in a similar role do it from home, you'll have a hard time showing why that wouldn't be a reasonable accommodation. But if it's a thing where they really need help, say, going to the bathroom or other things like that, that's not a reasonable accommodation. You can't ask your other employees to help with those personal things. So a lot of times that's what you're looking at is what's requested here, a reasonable accommodation. The easiest way to handle that is going to be to make sure you have a written job description that sets out what the essential duties are for the job, and then using those duties to say, okay, can this person with this disability do these essential duties if we make a small change? If they can't, you can still terminate. Go ahead. All right. Equal work and the Equal Pay Act basically says that men and women in the same workplace be given equal pay for equal work. They don't have to be identical jobs, but substantially equal. So if you have two practice managers or someone doing payroll and someone paying bills, different things like that, you just want to make sure that you're paying them generally the same. Okay. This one I see almost nothing about, but it is a law, so I like folks to know about it. The Genetic Information Non-Discrimination Act basically says that employers and health insurance too cannot use any genetic information, family, and that includes just general family history about employees to discriminate against them. It's kind of like the Age Discrimination Act. It's not a protected class, but it is in fact protected by this law. All right, this is another one. This one protects the rights of armed service members. And basically what it states is that returning service members have to be promptly reemployed in the same position. Now, there are certain times when you can move them to a similar position, but it has to be the same pay. All right. Now, this does not mean the same position that they had when they left. It has to be the same position they would have if they had not left for military service. And this can be difficult for small employers because it's hard to know, well, what would they have? What you're mainly going to find is, okay, let's think, would there have been certain benefits? If say Mary has been deployed, she's been gone 12 months. If she had worked those 12 months, she might have been entitled to an additional day of PTO. She has to come back and be rehired with that additional day of PTO. Okay. They're looking for the same seniority, status, and pay. All right. And we talked about whistleblowers generally earlier. OSHA also has a whistleblower protection that just refers to any sort of reporting of any workplace violation or law. Okay. So now we've talked about what it means to be at will and what the limitations on that are. We've talked about all the different laws that prohibit employer discrimination. Now we're going to talk about something that folks think they may think they understand, but they don't. Now, depending on what your role in your practice is, you may have received an offer letter that said you were an exempt employee or a non-exempt employee. What we are talking about is the Federal Fair Labor Standards Act. That is the act that says anyone who is hired and works overtime has to be paid time and a half. Okay. For example, and this, it also kind of sets out how pay should happen. But what we're really thinking about most of the time is this an employee who has to be paid time and a half anytime they work more than 40 hours? If they are an employee that has to be paid time and a half, if they work more than 40 hours, then they're considered a non-exempt employee. And those employees are almost always going to be paid with an hourly wage, just so it's very clear what you would have to pay them if they work more than 40 hours. If they are an exempt employee, on the other hand, then you never have to pay them overtime. And most of the time, they're just going to have a set salary. Okay. So the top three groups of employees most likely to be a wage claim are going to be salaried employees who believe they're owed overtime pay, hourly employees who contend they weren't paid for the hours worked, or restaurant workers who think they're due additional pay under the tip credit provision. And the things we're going to look at there are whether the salaried employees were actually exempt or not. So the FLSA has a kind of a complicated test, a series of them, about whether or not a salaried employee is actually exempt. So one example would be the white collar exemption, where the person has executive duties. And I'll sometimes have clients come to me and say, oh, well, we're going to use this. This is why I am paying our receptionist a salary and saying she's exempt. And I have to say, no, she may wear a white collar, she may dress very professionally, but if she's not regularly and customarily directing and supervising two or more employees, she cannot actually qualify for this exemption. She can't hire, fire, or for example, then she doesn't get the exemption. Now, we have certain things that are specifically considered exempt. Physicians and RNs are always considered exempt. If they are a registered or certified medical technologist and they have like 3 years or university plus a year of professional study, they're exempt. Dental hygienists are considered exempt, and certified PAs are considered exempt. So those folks are all exempt. You don't have to really worry so much about those. These, though, are things that are non-exempt. So licensed practical nurses, they're never going to be considered exempt. Paralegal, unless they have a separate, they might be licensed in LPN, but maybe they're actually your office manager or something and they manage other staff, then you would be looking at a different test. But just similarly, based on their education licensure, they don't count. Paralegals, legal assistants are never exempt. engineering technicians, bookkeeping, not exempt, and then cooks are not exempt. So one other thing I want you to know is that at the end of August, so just a couple of weeks ago, the Department of Labor sent out a request and said they want to change the rule so that to be considered exempt, you have to make at least, they're going to raise it so that it's at least $55,000 a year. It's actually $55,066. So during the Obama administration, he tried to get it higher, but at that point, the threshold was $23,000 and a few dollars. Under the Trump administration, they moved it up to $35,568. And that's where it sits. They're trying to raise it. And that's simply because we are all aware of inflation. If we use today's inflation rate with that $35,000 number that the Trump administration put in, we would be at $42,594 a year. But what this change, if they do put this through, then that means no matter whether they are an exempt, whether they have an education or whatever, if they're not making at least $55,000 a year, they're not going to be considered exempt, and you might have to pay them overtime. So what are these overtime violations? One is not getting the exemption right, or assuming all your salaried employees are exempt, not making the proper deductions and overtime weeks. You do determine overtime on a weekly basis. We don't get to look at the end of the month and say, well, it all evened out. That's not how the FLSA works. And it doesn't matter if your employees agree to however you want to do the math. They actually can't waive this law. The feds can still come after you. Misclassifying employees as independent contractors happens pretty regularly, particularly with new practices. Someone will come to me and say, I'm setting up a therapy practice. I'm going to have these 4 therapists working for me, but they'll all be independent contractors. Well, there are certain things that have to be true for that independent contractor relationship to be right. Usually you're not going to be providing them with all their equipment. You're not going to be providing insurance or benefits. You're not going to be directing them what they have to do every hour of the day. And usually they're not going to be working full time for you, and that they're going to be able to work for other people. So if those things aren't true, then a lot of times those independent contractors are really going to be found to be employees, and you would then owe both payroll taxes and possibly overtime. Not recording all hours worked or paying for all hours worked is a problem. It's always a good idea to have folks sign their time cards or time record or put it in themselves. And then if there's confusion between state and federal law, those would be other issues, but that's not usually a problem here. Most of these things I find don't happen very much, but that one in the middle, combined hours. Sometimes smaller practices will say, we pay Janice to as a therapist, and she talks to patients and does peer review or does peer counseling, other kind of counseling all day, but she asks us if she can make a little more money, and so we also let her clean the office every night. We pay her as an independent contractor to clean the office, but we have her do the other stuff on an hourly rate, and we just want to make sure we don't have to pay her overtime even though she's actually working 45 hours. That doesn't work. The only way you could actually do that with Janice is if Janice created an LLC, created her own business, and you contracted with that business to provide the cleaning services. You can't pay an employee for additional services and not pay them overtime. It all gets lumped together, even if the jobs are for different things. You can only ever prove that someone is wrong if you have records. And I have actually had to defend practices in wage claims where other physicians have brought in and said, hey, you didn't pay me all of my PTO, or you didn't pay me all of this. And the practice says, well, that's a laugh. You didn't work a single Friday in 2016. And the doctor said, prove it. And you know what? They couldn't, because they didn't actually keep any sort of records about when physicians were in or not. They could generally have staff say, well, I don't remember him being there very much, but I do think he came in some in the morning. Well, that's a problem. If a salaried employee shows up ready and willing to work of any part of a day, then they have to get paid for the day. So that's one of the things with salaried. They're not actually keeping their hours. So that's the thing. Just make sure you have some sort of time clock or logging in system, and that you keep a copy of those records. All right. So basic records, you want to know the name, the sex, the date of birth if younger than 19. You need to have a written thing stating any deductions you are taking out of a pay period or the pay, and then the regular rate of pay, your total hours worked, etc. I always like to make sure that any offer letter actually goes ahead and states when you're going to expect them to be there and what the normal hours will be and how they get paid based on that. All right. So moving on to another law that starts with an F. This one we're all pretty much, I always think of it as the maternity leave law, but that's because I have 4 kids. So this is the only time I personally ever involved with this, but I do get a lot of questions about it. So if you're a private sector employer with 50 or more employees, or you're a public agency, basically, or even like a private nonprofit receiving public funds, or a school, then you have to meet FMLA. What I will say is I find a lot of times small employers, maybe with only 10 or 12 employees, will sometimes have put in their employment manual that they will follow FMLA. I would never do that. If you want to give people leave, then spell out how they're going to get the leave. But I would never agree to follow this law, because then anytime the feds change the law, you're required to meet those changes when you wouldn't normally have to. So an employee, even if you are required to meet FMLA, they don't necessarily get FMLA coverage unless they've worked for you at least 12 months and they have 1,250 hours of service during those 12 months. So it might be someone who only worked for you 2 days a week wouldn't qualify as this. And they have to have been at a work site with 50 employees, all kind of co-located within 75 miles. The reason is they're trying to make sure it doesn't apply to really small employers. So it may not apply much to y'all. One of the things I would have this here, this is about I need probably to change this heading. This is about employee insurance, not health insurance. So if you're an employee in a practice, I do recommend that you make sure that your commercial insurance, general insurance policy covers employment issues. I find it's cheaper for practices than hiring someone like me. My hourly rate is higher generally than most insurance coverage. So it's usually helpful to get advice from me. You might not want me to go to court for you. I love to go to court, but I'll admit I'm not the cheapest. So one of the things you have to think about with that, you want to make sure you have coverage. You want that coverage to say if someone brings any claim for a wage claim or a harassment claim or a wrongful termination, that they will have counsel that will step in and defend you. All right. Now, I'll tell you right now, they are not going to defend you or pay any sort of premium if you violate that FLSA or neither wage and hour law. If you are aware that someone was sexually harassing someone else, they're going to consider that an intentional violation. They won't cover it either. They usually aren't going to cover punitive damages. So you're always going to want to make sure you're doing your best to meet your obligations. But it is important to know it's a great idea that whatever attorney you get, even if they are paid for by the insurance company, they do actually owe a duty to the practice, not the insurance company. But let's be real, they do have a relation with the insurance company, but it's usually a good idea and much cheaper. And it also, often, if your employees all know you have this employee insurance coverage, I find it also reduces the number of claims because they know you're not going to be afraid and want to just settle automatically. Okay, so the second biggest thing I get a lot of times are people calling me and they want to terminate an employee. And I don't particularly like terminating my own employees. Sometimes managing my business, I have to do that. I don't usually mind though terminating other employees for other people. But I do require that the documents be in place. So I am a big proponent of hire slow and fire fast. If someone is not the right fit for your business or your practice, you need to go ahead and take that person out. Letting someone stay in who comes in late or doesn't do their job or is difficult to deal with. Folks like that need to be told immediately what the issue is and then how they're corrected. And if they fail to do it again, tell them again. And then I like the 3-strike rule. Now, there are certain things you can't get 3 strikes for, right? We can probably think of those. But those kind of situations, the other situations, I like to do that. What I'll find though happens, I can think of a call just last week. And then a client said, hey, so I have this woman, she doesn't come in on time. In fact, she hasn't been coming on time basically ever since COVID. That's why we made that new timekeeping policy where people had to come in early before their first clinical visit. And it's just been a problem. And her supervisor's kind of tired of her. So she fell last week in the parking lot, and she has had some sort of problem. She hasn't come back. She's on crutches. I'm a little concerned about, when she's going to be able to come back. And it turns out that, we think we just like to terminate her now. Okay. You can already probably, based on this call, you think, So I'm like, how old is this person? Well, she's 62. How long has she worked for you? 7 years. All right. So for 7 years, you've had this employee, and you've put up with her repeated tardiness several times, but now you want to fire her after she fell in your parking lot? I think that's probably going to be a problem. Tell me what paperwork you have that shows that you counseled this employee in the past about her repeated tardiness or any other issues. Well, we talked to her. All right. Talking to someone is not a counseling session unless it is followed up by something in writing. So these are the sort of things that you have to do. Whatever you do, you need to put it in writing. Anytime someone comes to you with a complaint, no matter how far-fetched it seems to you, it needs to be put in writing, and you can write it up or they can write it up and sign it. And then you have to investigate. You have to investigate all of them. And the reason is that's how you set up your defensive shield in the event that someone in the future comes and says, hey, Susie sexually harassed me. And you say, really? And I told many people, who did you tell? Did you tell your supervisor per our policy? Because we don't see it written up anywhere. Well, if you never write up any investigations, that's not a good defense, right? So anytime any complaint comes in, you want to make sure you do an investigation. I include anonymous complaints in that. If you get in an anonymous complaint, I would still investigate. A lot of times those are going to be difficult to actually evaluate, but write it up and follow your same investigative process. So what are you going to do? You're going to start with whoever made the complaint, if you know who it is, and any witnesses, and you're going to talk to each of them and write up what they say. You're going to check the social media for folks to see if anything goes there. If you have enough space, then you're going to want to have whoever does HR or whatever to do the investigation, and then report it to management in writing. And then you want to say, hey, generally communicate the findings. You don't have to say what you have done to the employee. They don't need to know what the disciplinary action is or wasn't. That's not the complainant's position. You can't say, okay, we did find this, or we understand why you would be upset about that, but we did not find that a violation of whatever policy. If discipline is required, write it up and make sure it's in the file. Even if under your policy it counts as a verbal discussion, still write up that you had the verbal discussion on April 15th or whatever. Following that, it's usually a great idea if you can separate the employees. If you can't, then be prepared to have this kind of linger or to have to actually counsel both separately and together. Okay. So just some other best practices. As you're probably listening to this today, you might be writing down a few things and thinking about it. Make sure you have a hiring strategy that know what kind of people you want. Sometimes this can be a matter of values that you think about, or attitude, or whatever. If you have that written up, that can be helpful to use while you're interviewing folks to give it to them. At my law firm a few years ago, we found that a lot of the people we hired after we hired them seemed to have a different sort of work ethic than what we were looking for. So we rewrote our values to make it very clear that we are looking for people who are 100% accountable, 100% accountability, and that are going to work with others. We say work as a team sport. Writing up those things and going through those in the interview process helps us already kind of be aware of who is and isn't maybe going to do that. And if after they're hired, they turn out not to want to meet those values, say, well, as I told you, it's really important to us that we have people here who are happy to help, whether it's your job or not, that you're willing to pitch in. And those kind of things are helpful. Make sure you have a written position description for every job. Do not wait and do it after the fact unless you're going to have that person agree to it again. It's better to do it up front and to provide it either in the posting and have them sign off on it, or to attach it to the offer letter. So it's very clear it applies to them. Watch out for social media. I always tell everyone, just don't use social media for anything related to patients, clients, employers, or work. I do like employment agreements, like you imagine, of course, for all physicians, PAs, NPs, pharmacists, and then whoever your kind of top management folks would be. Job descriptions mentioned that. You should have a written employee handbook, and I always recommend having that reviewed by an employment lawyer in your state. And that one way or the other, if you have a handbook or not, you need to have a complaint policy that every person in your practice has signed. It's great to have a dedicated human resources person. A lot of times I find those practices don't need a full-time person. They can usually get by with outsourcing HR, and there's a lot of HR companies out there. For instance, it's just easier sometimes to have someone like that draft that termination or that offer letter or those job descriptions and make sure they're there. Okay. Progressive discipline when possible. I do think this is good. I do not like the things that where your manual tells you have to go back and have 15 different steps or where you can appeal. I do like very simple things, kind of the 3 strikes and you're out issue. Do performance evaluations and don't lie. I know it's always awkward to tell people that they're not quite making the mark, but it's so much easier to be upfront about issues and then have them go. Actually, here at my firm, we're all kind of amazed. The last 4 people I intended to fire all quit a week before I met with them. And that is because they were under they're not surprised. I've now met with them 3 different times and said, hey, this is what our expectation is. Here's what we're seeing. We need to bring this up. All right. If you do that with folks 3 times, they've usually either made the decision that they're going to fix that, or it's something they can't fix, or something they don't want to fix, and they will be happier somewhere else. Keeping the right person on is always a bad decision, both for you and that person and all the other folks in your practice, because your culture is only going to be as good as your last employment decision, whether you actually hired that person, whether you fired that person, whether you actually acknowledge the issues with this other person's performance or not. Always write down everything. You've got to have documentation, and then be fair and respectful. Like there's no need to be rude. It's like Mary Poppins in the old Disney movie. I'm never cross, but you have to be firm. And it's just easier to be that person all the way through. Okay. If you're an employee, of course, you're going to be trying to get your best deal up front. You want to get any sort of thing. You always have the best negotiating position at the beginning, right? So try and get your best deal up front. Know what you signed. If you don't have a copy of whatever you signed, ask for one. They're required to give you a copy of your signed employment agreement. Ask questions as you go. Ask for a job description. Particularly if you think your job description's changed. It doesn't have to be something you're rude about. My legal assistant came up and said, hey, you know what? You asked me recently to do this, this, and this. Before you kind of told me these are the most important things I did. How do these things fit in? And I would really appreciate if I could have a new list of what the top 5 things you want from me. It was great. It helped us fix the relationship, make everything we were on the same page. It didn't need to be adversarial at all. Review the employee handbook and make sure you have a copy. And then you want to follow the complaint policy. It's the same with employees as it is for employers. If something happens that makes you uncomfortable, you're unsure about, you need to go report it up front. All right, questions. Let's see. Here's a question. Please, you're welcome to put them in chat. I don't know, or I guess you could maybe raise your hand. One question. I just pay all my employees on salary because it's easier. Is that okay? You can pay your employees on salary, but that doesn't mean you don't have to pay them overtime. So if some of your employees are actually non-exempt, then you have to make sure you're tracking their hours as well. So a lot of times, if you're handling it right, it's not always easier to pay them a salary. All right, what do you do if an employee comes in late or leaves early and they've used up their leave? In other words, I guess here we're talking about a non-exempt employee who's paid hourly. If they don't have leave, you don't have to give them leave, okay? So both in Georgia and in South Carolina, you don't have to give employees benefits. But if you make a decision to give them benefits, you have to give it to all employees, obviously, regardless of their classification. And then you have to actually provide the benefits. But sometimes folks accrue leave over the year and they've used up their leave, say by April, but they've been sick or they've had children with issues and so they've had to leave. What do? That's up to you, but I always like to say people cannot get leave without pay unless the management approves, because someone who is not coming to work on time or leaves early, you want to have the ability to discipline them or terminate them for that. So it's up to you, but I would write it up and again, counsel with them and make sure they're following the leave policy before you allow folks to leave without pay. We require employees to be at their desks 15 minutes before their first appointment because so many used to come in late. Do we have to pay them for this time? Yes. If you require your employee to be at work at a specific time, even if their clinical appointments start later, you have to pay them from beginning the time they show up. And then let's see. This is a question where an employee was confronted. I think this happens pretty regularly. An employee is confronted about a performance issue and then is sick the next day. And they want to know, do we have to actually let her take sick leave if we really think it's not true? If you give employees sick leave, you should specify in your policy if they have to give a physician note or whatever. And I think if they're going to be out more than 3 days or more, they should be required to provide a physician note. But it's up to what your policy says. If it just says people cannot come in if they're sick, then that can create a problem if you don't have a good policy. But you can't ask specifically what's wrong with the employee, but you can ask them for a physician note if your policy allows that. Are there any other questions?
I don't think there's any more questions in the chat. Thank you so much, Kelly, for this valuable information. And this actually this presentation aligns with some learning opportunities that we have. For continuing education opportunities, please visit formedtrainingcenter.com/hybrid solutions. Use the coupon code HYBRIDGE20 to receive a 20% discount. And this one kind of aligns with what you talked about, some of the disability. This is a learning opportunities for physician assistants and MDs. Center for Leadership and Disability Training Opportunities, Georgia Statewide Disability and Health Program, Healthcare Provider Training Opportunity. There's free continuing education credits when you access and complete these trainings. The first one is Responsive Practice 1, providing healthcare and screening to individuals with disabilities. And the second one is Accessible and Adaptive Communication. So this is no cost to you. You've received free education credit, continuing education credits. Our next webinar is the third Tuesday of October. And this webinar will also be around the disability training. So if there's any physicians, if we have any practice managers, you want to give this to your physicians or physician assistants, and we will assist them on this webinar to complete the trainings at that time. If there's no more questions, again, thank you all for joining our webinar and have a great day.